All right, so the class is being recorded. Again, take care of your privacy. The class is being recorded. Take care of your privacy. All right. Okay. All right. So, guys, in the last class, we talked about leases. If you do remember, we talked about leases at length, and we completed the discussion on leases, and we saw a past paper question on generally the question of transfers and also still on leases. Okay. Now, based on our discussion in the last class, like I said, we completed the question on leases. We completed leases. So if there is a question on leases, my only hope is that you will be able to understand, you will be able to answer the questions, and you will be able to interpret the questions, because questions on leases are very direct questions. You just need to understand what the examiner is asking you. And once you do that, you will be able to interpret and answer the question. There's nothing complicated. Now, so far, we have talked about, so I'm going to go through the key things that we talked about. If you have a question in any of them, then you will be able to let me know so that we talk about something or we answer the question if you have. Okay. All right. So the first thing we talked about was what is a lease. Okay. We talked about what a lease is. We discussed what a lease is. If somebody is talking to you about a lease, what is it that you need to understand on what a lease is? Are you able to know what a lease is from seeing it? Guys, most of the time, you will need to understand a question just by reading it. What I mean is, if the question is setting on leases, if the question is being set on leases, you need to be able to look at the question and see a lease. Okay? If you read the question from the first part to the last part without understanding anything, it becomes a problem. Okay? It becomes a serious problem. So you will need to read the question, and from the question, you need to understand what the examiner is asking you. Understand what the examiner is asking. Because if you do that, then everything else becomes very easy. Okay? All right, so we talked about the meaning of a lease, and then we talked about the various documentation in terms of leases. We talked about the lease agreement. We talked about the certificate of lease. We talked about a sublease. Okay? Now, if you have a question on those three, again, you know what you do. The next thing we discussed was the parties in a lease agreement. Parties, who are the parties in a lease agreement, and why was this important? This was specifically important because, remember, when you read a question like the one that we did read in the last class, when you read a question, the examiner will be giving you just names. Okay? The examiner will just be giving you names. Are you together? The examiner will be telling you that, hey, this question is this. This question is this. So from that perspective, you need to know. And you guys don't understand it until you get a question in an exam where the examiner is giving you 6 names, or the examiner is giving you 5 names, or even in a question where you get 2 people, you need to be able to understand who the people are, okay? Because the examiner will give you a question and you'll be told, Peter was doing this. Advise Peter on what he needs to do, or advise on the duties of Peter. Now, you can't advise on the duties of Peter unless you know who Peter are. So in terms of leases, we say we have the lessor and we have the lessee. Now, the lessor sometimes is the landlord, referred as the landlord, and then the lessee is also the tenant. So the tenant is the lessee and the landlord is the lessor. We talked about the elements of a lease, what goes into a lease. What are the key elements of a lease? which is the question of parties, the question of the property, the question of time, and the question of exclusive possession. And then we said that tied to that was the question of drafting of a lease agreement. Are you able to draft a lease agreement right this minute? If I was to give you a question and ask you to draft a lease agreement, are you able to draft that lease agreement right this minute? Now, if you're not able to draft a lease agreement right this minute, then that again is a problem. But it is something that you can always do. Now, in terms of drafting a lease agreement, I've said just understand the key elements of a lease, and then everything else will just follow. Okay, we went and talked about the differences between leases and licenses. What is a license and what is a lease? What is the factors that distinguish between a lease and a license? We talked about that, guys. So there is no reason at all. There is no reason at all why you are not able to identify a lease from a license. Are you together? There's no reason at all why you're not able to identify a lease from a license. Are you together? That is okay. And then we talked about now the duties of parties, the implied duties and the implied covenants. Now, guys, we said that at any time, there is a lease agreement. Anytime there's a lease agreement, or anytime there's a lease transaction, or a lease relationship, or a lessor-lessee relationship, there are certain duties that are implied. Implied simply means they don't have to be made clear in writing. They don't have to be in the lease agreement. They can be in the lease agreement, but they don't have to be in the lease agreement. They are implied. For instance, the duty of the lessee to pay rent. You have the duty to pay rent, and that is an implied duty. Whether it is written in the agreement or it is not captured in the agreement, you have an implied duty to pay rent. So you have to pay rent wherever you're staying. Lipa rent tafadhali. Okay? And then after that, we also talked about the question of the remedies of parties. This is very, very important, guys. Remedies of parties. Now, assuming that you have breached your duties, like I've just said, that in the first instance, we have the duties of parties, the duties of the landlord, and the duties of the tenant. Assuming that the landlord has breached or has violated his duties, what are some of the remedies of the tenant? You as a tenant, what can you do? Assuming that the tenant has violated their duties, you as a landlord, what should you do or what can you do? Okay. And then lastly is the ways or the different ways in which you can terminate a lease. Different ways in which you can terminate a lease. How do we terminate a lease? The various ways of terminating a lease. And we discussed that because you will be given that as an option in the question, and then you're told that advise this person on how they can terminate the lease or the various ways in which a lease can be terminated. Guys, are we together?
Yes,
Gustavo?
Yes.
All right. Now, based on the things that I've said, is there any person that is not understanding either of the subparts that I've mentioned? Something that is not making sense to you, you've tried reading it, is not making sense. Is there any person having a question or a difficulty on the issues that I've already addressed or things that I've mentioned? I've not discussed them because we discussed them in 2 classes. Okay, so I'm just asking right now, is there any person that is not understanding each of the points that I've mentioned right now? All right, then that is okay. That is fine. So we will be looking at exam past papers so that you keep on revising and sharpening your understanding of the question of leases. But until then, please keep reading. Now, today I want us to start from control tenancies, the control tenancies. Now, control tenancies are also leases. Control tenancies are also leases. Now, everything else that you've learned about leases, from the very first time we started on talking about leases will apply to control tenancy. Okay, they are just control leases. So they are leases, but they are controlled leases. Okay, so when we talk about control tenancy, a tenancy is a lease. Okay, a tenancy is a lease. which is an arrangement between the tenant and the landlord. It is a lease. So controlled tenancies are just leases. Okay, they are just leases, but they are controlled by the state for the reasons that I'm going to mention. Okay, so that is control tenancy. So as we discuss control tenancies, just understand that at the back of your mind, understand that everything else that you've learned about leases, everything else that I've taught or you've met anywhere regarding leases will apply to controlled tenancies. They'll apply to controlled tenancy. Are you together?
Yes, we are.
Okay. All right, so let us start with the meaning of a controlled tenancy. Let us start with the, somebody's having a question? Okay, nobody. Nobody's having a question. So what is the meaning of a controlled tenancy? Or why are these tenancies controlled? Why are these tenancies controlled? Now, there are essentially two tenancies that are controlled. There are essentially two tenancies that are controlled. The first one is a tenancy for a shop, hotel, or a catering establishment. Okay? A tenancy for a shop, hotel, or a catering establishment. That is the first tenancy that is controlled. The second tenancy that is controlled is the tenancy for residential houses. Okay? And not just any residential house. It must be a residential house whose rent, where the rent does not exceed 2,500. So if you are staying in a place where the rent payable is 2,500 and it is residential, then that becomes a controlled tenancy. It is a controlled tenancy. Are we together? Now, let us go back. Let us go back and discuss now the meaning of a controlled tenancy under the Act. So we're going to look at two acts generally. The first act we're going to look at is the Cap 301. That is the question to do with the Landlord Tenants, Hotels, Shops and Catering Establishments Act, Cap 301. And then we will look at also the Rent Restrictions Act, the Rent Restrictions Act. But at the back of your mind, guys, just understand that I've said that these are controlled tenancies. They are just leases that are controlled, okay? They are leases that are controlled. They are controlled for specific reasons. The government is trying to control them for specific reasons. For instance, commercial buildings, and that is the shops, hotels, and catering establishment, the government controls them as a way of supporting the economy. So if the government wants to support the economy to ensure that the economy is growing, and where is the economy going to grow? The shops and the offices. We have the hotels and the catering establishments. That is the backbone of the economy in terms of the commercial sector. So that is the reason why the government is controlling these tenancies. Okay. Number two is also a little bit of control when it comes to the residential places where the rent payable is 2,500. Now, the reason why the government is controlling that is to safeguard the interest of the low income earners and those that are living in them, most of the slums and people that are, the right to housing, really to support the right of housing for these less privileged people. In the we call them the low income earners, or people that are staying in the low income zones. So the government must come in and protect their interest. The government must come in and protect their interest. It means that if rent payable is 2,500 and below, then you need to be protected by the government so that your right to housing is safeguarded. So that is the main reason why the government is interested in safeguarding your interest in as far as residential places is concerned, so long as your rent is below that amount. Because if you're paying that rent, then you fall within the category of the protection of the government. So that is the reason why these leases, they're just normal leases, they're normal lease agreements, but they will be falling under the specific protection of the government. The same way when it comes to businesses, shops, hotels, and catering establishment, you must be protected by the government because that is also a core feature of the economy. So I'm going to put up the act. I'm going to bring up the act, and that is the landlord section 2, 5. All right there. So tell me when you see my screen. And I want someone to read for us. 3.5, section 3.5. No, section 3.5, sorry. Section 2. Somebody read for us what is a controlled tenancy under section 2.
A controlled tenancy means a tenancy of a shop, hotel, or catering establishment, A, which has not been reduced into writing, or B, which has not been reduced into writing, and which, Roman 1, is for a period not exceeding 5 years, or 2, contains...
No, you're confusing. You read that thing wrong. Start over.
Okay.
Read it clearly.
A controlled tenancy means a tenancy of hotel or catering establishment, which has been reduced into writing, or which has been reduced into writing,
You're not. You're reading those two things the same. They're not the same. A.
Okay. Let me retake again. Controlled tenancy means a tenancy of a shop, hotel or catering establishment, A, which has been reduced into writing, or B, which has been...
Where? Are you okay? What are you reading? You are not seeing the difference between those two statements. What you're reading is the same thing, but they're not the same. Start again until you get it.
Okay. A controlled tenancy means a tenancy of a shop, hotel, or catering establishment, A, which has not been reduced into writing, or B, which has been reduced into writing and which is for a period not exceeding 5 years, or contains provisions for termination otherwise than for breach of covenant within 5 years from the commencement thereof, or relates to premises of a class specified under subsection 2 of this section.
All right,
Provided...
thank you. Thank you. And of course, the proviso there is a provider that no tenancy to which the government is a party shall be a controlled tenancy. Okay, so let us look at what a controlled tenancy is and look at what the catch is. Okay, now a controlled tenancy is a tenancy on the very far side, a tenancy for a shop, hotel, or a catering establishment, which has not been reduced into writing. Okay, so any tenancy for a shop, hotel, or a catering establishment that has not been reduced into writing, that is a controlled tenancy. Okay, so if you see any tenancy for a shop, hotel, or a catering establishment that has not been reduced into writing, then that becomes a controlled tenancy. It becomes a controlled tenancy. Are we together? Number 2, if it is reduced into writing, then the period must not exceed 5 years. The period must not exceed 5 years. So the first one is that any tenancy for a shop, hotel, or a catering establishment that has not been reduced into writing, a verbal contract or a verbal tenancy, is a controlled tenancy. Okay? But if it is reduced into writing, it is only a controlled tenancy if the term does not exceed 5 years. That is number one. Number two, if it contains provision for termination otherwise than for breach of covenant within 5 years from the commencement thereof. Okay, so let me explain that. But on the very first side of it, the first thing you need to understand is that any tenancy for a shop, hotel, or a catering establishment that is not reduced into writing is a controlled tenancy. So long as it is not written, it is a controlled tenancy. It doesn't matter whether it is for 30 years. It does not matter. So long as it is not written, it is a controlled tenancy. Number two, if it is written, assume that we have one that is written, then the term in that written agreement should not exceed 5 years. The term in that written agreement should not exceed 5 years. And then number two is that it should contain, if it contains a provision for termination, otherwise than for breach of covenant, then it is a controlled tenancy. Okay, what is this thing we are calling provision for termination otherwise than for breach of covenant? Okay, now the general rule is contracts will only be terminated if a covenant has been breached. Okay, contracts are only terminated if there's a breach of a covenant. I don't know whether you are understanding what I'm saying. Are you understanding what I'm saying? Contracts are usually, okay, terminated, or leave alone contracts. Leases are usually terminated if somebody has violated a covenant. So if you violate a covenant, automatically we are going to be terminating. Are you together? We shall terminate the lease. However, the lease that we're talking about here, the controlled lease, will have a clause indicating that this contract may be terminated at any time. It doesn't matter whether there's a breach or not. It will be terminated at any time, either by consent or part. And you've seen this. Let me give you a practical example. When you draft your contracts, for those who've drafted contracts or seen contracts or even employment contracts, there's normally a termination clause in that contract. Okay, there's normally a termination clause. Okay, the termination clause is a clause that simply says that this contract shall be terminated at any time by either party giving a notice of termination or a 30-day notice of termination to the other party. So essentially we are saying if this contract is reduced into writing and it has a termination clause, then that is a controlled tenancy. Okay, so what are we saying? Number one, it is not reduced into writing. Number two, it is reduced into writing and the term is for less than a period less than 5 years. And then number two on that point is that it has a termination clause, which is not on breach of covenant. Guys, I want you to understand that point, and we will not move forward until we understand that point. Are you together? We shall not move forward until we understand that point. Guys, mmeelewa ama bado? Have we understood? All right. So I've said, guys, there are two types of termination clauses. There are usually two types of termination clauses. Okay. There's a voluntary termination clause, and then there's termination on violation. Okay. There's a voluntary termination clause, and then there is termination by breach. For instance, if we have a contract, me and you, we have a contract, I will have in that contract maybe a termination clause saying that either party voluntarily may terminate this contract by giving notice. Okay? That is a voluntary termination clause. You just terminate and give 1 month notice or 2 months notice. You all know that. And then secondly, there's a termination on breach, where you'll be saying this contract shall be terminated effectively upon either party breaching the covenants or breaching their obligations under the contract. Are you together? So the one that makes this lease agreement a control tenancy is the one that has nothing to do with breach of covenant. So if you have a contract and in that contract you have a termination clause that is not on breach of contract, then that is a control tenancy. Guys, tunaelewana?
Yes.
Just,
All right.
just a question from my end.
Put up your hand. Hey, this is my class. If you have a question, put up your hand. But I want you guys to understand where this aspect is coming from. Because once you are able to understand it, then you will be able to understand and even answer the question that we will be looking at later in this class. So make sure before you go, don't just go with the flow like, okay, everyone is fine. Everyone is saying they're fine. My friend, please, if you don't understand it, put up your hand. We are going to address it, okay? We're going to address it. All right, questions. Number one, let's start with someone called Musyoka Dolo.
Thanks, Mwalimu. Just a question. I'm just trying to understand 2B. So if there is a voluntary termination clause, why do we need the statement reading within 5 years from the commencement thereof? So does this mean that you should exercise this clause within those 5 years? Or why do we have it there?
All right. So in terms of the termination, it simply says that if you have a termination clause, remember why 5 years is there. 5 years is coming from B1. A controlled tenancy should not exceed 5 years. Okay? A controlled tenancy should not exceed 5 years if it is written. Okay? So if you have a clause indicating that this, because normally contracts are terminated upon the lapse of time. We talked about termination of leases last week, and we said one of the ways in which a lease will be terminated is upon the expiry of time. So our lease here can only go for 5 years. So it means at the end of 5 years, it will be terminated. But two things will happen. Before the end of 5 years, two things will happen. What are the two things that will happen? The first one is a voluntary termination before the end of 5 years. Okay? So within these 5 years, we can have a voluntary termination by saying, before the end of 5 years, any party can terminate this contract. Because remember, if it passes 5 years, there is no there's no control tenancy. So we are saying that within the 5 years of the existence of this control tenancy, any party can terminate this agreement by giving a notice, for instance. That makes it a control tenancy. Okay? I don't know whether if you're not understanding, just say it so that I can go over it again.
No,
You're not speaking.
It's clear. It's clear.
Okay. Omondi?
I wanted to request that you go over it again.
But you're not asking that question. See, this is why I'm catching you guys. You're not asking it. You guys said everything was clear. So after he has asked, that is when you realize you're not understanding. Guys, can we ask questions? Stop playing. Stop playing. Ask the question. Some of you are not understanding what I'm saying, but they're just there. They don't want to talk. All right, it's how. Let me explain again. Somebody's microphone is on. Somebody's video is on, and they're in the darkness. John Ngugi, where are you headed to? in the darkness? Hmm? Are you taking things in your personal hands? Calm down. Just go back home. Everything will be fine. All right, so let me explain the 5 years thing. So guys, the 5 years, let me highlight it for you. These 5 years that I've just highlighted in green has nothing. It has no relevance here. And this is why it has no relevance, okay? Because controlled tenancies are only up to a maximum of 5 years. So we are simply saying that if you have a controlled tenancy that is written, which is of course up to 5 years, and you have a clause in that controlled tenancy agreement that says that you can terminate that agreement anytime within the 5 years, voluntarily without breach of contract, that is a controlled tenancy. I don't know whether I can get another word that is different from what I've just said. I don't know whether you guys are getting what I'm saying. So, controlled tenancies are only for a period of 5 years, okay? 5 years. So, if within the 5, because at the end of the 5 years, it will terminate. So there's normally a termination at the end of the 5 years anyway. But you can have a termination within the 5 years. Before 5 years, you can have a termination. So if that termination that you have within the 5 years is one that has nothing to do with breach of covenant, then that makes it a controlled tenancy. Are you together, guys?
Yes.
All right.
It's normally.
All right. All right. That is proper. Now, that is a control tenancy. So there are two sets of control tenancies. The first set of control tenancy is, okay, is a control tenancy that is for a hotel, a shop, or a catering establishment, and it has not been reduced into writing. That is the first one. The second one is one that is reduced into writing. It is for a hotel, shop, or a catering establishment, but it is reduced into writing. And if it is reduced into writing, it must have either of the two. It must have either of the two. The first one is that the term must be for 5 years. The term must be for 5 years. Or it must contain a clause for terminating that lease agreement or that tenancy agreement anytime before the 5 years for any reason otherwise than for breach of contract. So either, so you can have a lease agreement, a tenancy agreement that is reduced into writing, but does not specify the term, but has two. Guys, I want you to understand this point also very clearly because it is very important. So when you look at this, let me, it's not highlighting itself. Look at that, guys. Look at whatever I've highlighted in yellow, for instance. That is yellow. I hope it is visible. If it is not, let me enlarge my screen. I hope it is visible now. The word or, you can see the word or there, okay? Now, the word or simply means they don't have, those 2 points, point 1 and point 2, don't have to coexist all at the same time. It means you can have one set of agreement reduced into writing, okay? It is for a period of 5 years. That is sufficient to make it a controlled tenancy, okay? You will have another one reduced into writing, does not specify the term, but has a what? A termination clause within the 5 years, or a termination clause within 5 years. Then that is a controlled. So A, B1, B2, 3 sets of agreements. So A, not reduced into writing. B1, reduced into writing, the term is for 5 years. B2, reduced into writing, it has a clause. Are you together? So either or. And then the question that will come is, how then do you make, what the hell is this? Okay, how then do you make an agreement exist out of a control tenancy? How do you make agreement not become a control tenancy? How do you take an agreement out of the control tenancy? Because remember, guys, nobody likes control tenancies. Nobody likes controlled tenancies. I've already said that. Nobody likes controlled tenancies because they are controlled. Because they are controlled, nobody likes them. So your client will want you to explain to them, how do you take out an agreement or a tenancy out of the controlled tenancy? Somebody tell me. Tell me, put up your hand and tell me, how do you take an agreement out of a controlled tenancy? Yes, Omwenga, start with you.
Thank you. If you reduce it into writing and exceed the 5-year limit.
That is the first one. You reduce it in the writing and you exceed the 5-year limit. Okay, that is the first one. And then number 2. Bernard?
Yes. Hello.
What is yes? What is yes?
Oh.
Yes.
Oh, sorry, sir. You can add a termination clause that does not relate to breach of contract.
Wewe kwa wapi? Ile
Niko
kichapo
Nairobi.
utapewa. Utapewa kofi. Mpaka unaona nyasi inapanda. Kumbe wewe ndo unashuka chini. No. That is not what we've said. That is exactly the opposite of what I've said. I've said if you have a clause that has nothing to do, a termination clause that has nothing to do with breach of contract, it is a control tenancy. That makes it a control tenancy. My friend, tuko sawa? That makes it a control tenancy. Yes, Gisore.
You can create a provision for the termination other than the one for breach of contract, but it has to be more than 5 years from the commencement.
Wewe.
Why not?
What are you saying? Repeat. I want you to repeat word for word what you said. You can create.
I have said when you're creating a provision for termination other than the breach of contract, it has to be more than 5 years from the commencement for
So
each
you
not to
create
be a
it by.
control tenancy.
You create it by. In writing.
Yes, in writing, in
And
the
then?
contract itself.
And then?
But it has to be more than the 5 years from the commencement.
More than
for each
5
to come
years.
into- Yes.
And what does one say?
One
does-
say for a period
what-
not exceeding 5 years. You've asked if you can how to create a contract that is not for control tenancy. That's what you've asked, so that's what I'm answering.
You sure that is what you're answering?
Okay, I stand guided.
Nobody will guide you. Keep standing. Listen. Anytime a contract is in writing and the term is for a period more than 5 years, it is not a control tenancy. Anytime it is written and the term is for a period of more than 5 years, it is not a control tenancy. Okay? Are we together?
Yeah.
Are you together? And
Yes.
it cannot have any clause for termination that is not related to breach of contract. So you can have a contract. The first one, you can have a contract for. You reduce it in writing and make sure it is 5 years, not more than 5 years. That is the first way of making it control tenancy. But if you want to make it out of control tenancy, you make sure that is a contract that is more than 5 years. That is how you take it out of control tenancy. Number 2, if the provision of B2 says that it has a termination clause, okay, that is for anything other than breach of contract, then how do you take it from there? you remember, the most important thing is not the period of the termination. Okay, the most important thing is the termination clause. So if it has a clause for anything other than breach of covenant, then that is a control tenancy. So how do you take it away from that? By making sure that the contract can only be terminated after or due to a breach or a violation of a covenant. So you create a termination clause which is only for the breach or the violation of a covenant. So if it has anything that is not a violation, okay, that is not a violation of the covenant, then that does not become a controlled. It becomes a control tenancy. So how do you make sure that is not happening? By clearly having a clause in the contract that insists that the termination will only happen if the contract has been violated, or the covenants have been violated. So there are two basic things. The first one is reduce it into writing and make sure the term is for 5 years and above. Okay. Number two, have a clause in that specific contract that indicates that you shall only terminate when a party has violated any covenant or their duties within the tenancy agreement. So don't have it confused. Let not the 5 years confuse you. Let not the 5 years confuse you. So is that clear now? Are we all together on the same page? Now, in practice, you'll see parties having 5 years plus 3 months. Somebody will have 5 years plus 3 months, 5 years, 6 months, 6 years. Okay, so 5 years, 1 month. That is a way of escaping the jurisdiction of the control tenancy. So that is how you, escape the jurisdiction of the controlled tenancy. All right. Now, the next thing that you need to understand, guys, the reason why this thing is controlled, I've already explained that. Now, the reason why people don't want control tenancy is because it is controlled. Now, what is the effect of it being controlled? You, as the landlord, you can't even decide how much rent you're going to charge on your property. Rent is fixed by the tribunal and by the minister. Okay? Number two, you cannot fix the service charge. You cannot terminate the contract the way you want. So it is controlled. The property is yours, but the government will decide for you how much rent you need to charge, how much service charge you need to charge, how much notice you need to give to your tenants before you chase them away. So all that. So because of that reason, landlords don't like control tenancies. So how do you avoid it? By inserting that clause, or normally the easiest one is to just say that the lease shall be for a period of 5 years and 3 months. So you escape the jurisdiction of the tribunal by making sure that it is more than 5 years. All right. The next thing that you need to understand is the question of termination. How do you terminate a control tenancy? Now, guys, before I go there, remember, the examiner knows exactly what you're thinking right now. And what you're thinking is you're waiting for a question, and the moment you see the hotel, shop, or a catering establishment, you will automatically think it is a control tenancy. No, not all tenancies for shops, hotel, or a catering establishment is a controlled tenancy. Okay? So it only becomes a controlled tenancy if it is not reduced in writing, or if it is reduced in writing, it's for a period of 5 years. And it has that clause, or it has that clause. So guys, don't always rush because you've seen hotel or a catering establishment or anything else. So, and sometimes also the examiner will just give you, they'll not say hotel, or they'll just give you an example of a shop. John is renting out the property and using it for maybe a place where he's selling this. The fact that he's selling something there, that is a shop. The examiner will not say a shop specifically, or hotel or a catering establishment. You'll be told maybe it's a restaurant or something, or they'll not mention a restaurant. What is the difference between a hotel and a restaurant? Wengi wenyu wanakula tu. You don't know the difference between a hotel and a restaurant. Sasa ndo unaitisha mbili. Okay, so make sure you understand all the catering establishments. Okay, kabla uitishe sasa, jiulize niko kwa restaurant ama niko kwa hoteli, whichever it is. Okay, because the examiner will not say hotel or a shop or a catering establishment. They just give you one of them. Okay, they'll say that James or Jane is using this property, is cooking here, doing this and doing that. So you'll need to understand whether that is a catering establishment or not. Okay, that is the first thing. The next thing is that you need to understand the term. The fact that it's a shop or hotel or a catering establishment doesn't mean it is controlled. You go to the term. Okay, is it reduced in writing? If it is reduced in writing, then you go to the term. Is the term for 5 years? Or does it have a clause for termination other than for breach of contract? That is how you do it. So don't rush, please. Just take your time, read the question, and tick as you outscore and underscore the important factors. That is that. So how do you terminate a controlled tenancy? How then do you terminate a controlled tenancy? How a controlled tenancy is terminated? So the first thing is that you need to understand the obligation, the rights of parties in a controlled tenancy. So who are the parties? The landlord and the tenant. Okay. Now the landlord has the right to terminate. Okay. The landlord has the right to revise the rent upwards, or the landlord has the right to increase the service charge and all that. The tenant has the right to request reassessment of rent, that is a reduction of rent or a reduction of service charge. So anything that you want to do, anything that you want the other person to do. For instance, if you are the landlord, you want the other person, the tenant, to leave, or you want the person to pay more rent, or to pay more service charge, or to do something, or maybe to do some repairs, then you will have to send them a notice. So the first thing is a notice. So any party, either the tenant or the landlord, that wants something to be done in that specific agreement, that something to be done is either you want to terminate or you want to reassess the rent. They're the two constant ones. Or you have to do repairs. You have to send a notice. So notice. The notice is sent to the other party. So this notice is sent to the tenant or the landlord. Okay? It must be a 2 months notice. A 2 months notice. Again, this is also part of control. It is a part of control. You cannot just wake up and terminate. You just have to give 2 months. You can't give 1 month notice unless both parties have agreed. The minimum requirement is 2 months notice. So you have to give a 2 months notice. Now, within the 2 months notice, the person that has received the notice, either the landlord or the tenant, okay? Either the landlord or the tenant, they will have the right, number one, to do as the notice requires them to do, to terminate the contract and leave, vacate, or they will have the right to refer the matter to the tribunal. So if within these 2 months, you don't feel like terminating the lease or doing as the landlord has told you, or the landlord is not feeling like reassessing the rent, then after 2 months, the matter is referred to the tribunal. Okay, now which tribunal is this? The BPRT, that is the Business Premises Rent Tribunal. The Business Premises Rent Tribunal. Are you together? That is the tribunal that that will deal with questions to do with the controlled tenancy in terms of hotels, shops, and catering establishment. The business premises. That's why the tribunal is called business premises, the BPRT. Okay, so you refer the matter to the BPRT, and then the BPRT, of course, shall entertain the application, entertain the reference, and then give the orders. So the BPRT can say, fine, increase the rent, reduce the rent, terminate the lease, or do the repairs. So the BPRT will have the decision either to uphold the notice or to throw away the notice or to modify the notice. Okay, that is the BPRT, the tribunal. All right. So after that, any party that is aggrieved by the decision of the BPRT is supposed to go to the ELC. So if you're not happy with the BPRT, then you go to the ELC. Right together, that is Environment and Land Court. That is where you appeal. So any appeal from the BPRT, you go to the Environment and Land Court. Okay. All right. So what are some of the powers of the BPRT? What are some of the powers of the BPRT? Now, these powers of the BPRT are the same powers of the Rent Tribunal. So if you're writing, write down the powers of the BPRT against the powers of the Rent Tribunal. Against the powers of the Rent Tribunal. Powers of the Rent Tribunal. They're the same powers. They are the same powers. All right. So the first one is to fix rent. They have the power to fix rent. The power to fix rent. That is the first one. The power to fix rent. Okay. Number two, the power to fix the service charge. They decide what is the rent, what is the service charge. The next one is the power to decide what is a controlled tenancy. They have the power to decide whether the estate or the property is a controlled tenancy. Okay. They also have the power to order for repairs. So if there's something wrong with the building, they will come and order the landlord or the tenant to do the repair. They have the power to order repairs. They have the power of inspection. They can come and inspect. They can do health inspections as well. They have the power to summon parties. They have the power to summon parties. They have the power to order damages. They have the power to order either the parties, the landlord or the tenant to pay damages, as well as payment of compensation, as well as payment of cost. Okay, so there are general powers, some of the general powers of the tribunal, and this is both sides, the rent tribunal and the tribunal which is the BPRT and the rent tribunal. So they have all those powers. They have all those powers. Okay, so anytime you are dealing with the BPRT, just know that the powers of the BPRT are those. If you are told to discuss the powers of the tribunal, first you understand which tribunal is this. The tribunal is the BPRT, the Business Premises Rent Tribunal. Okay, and then what are the powers of the BPRT? Like I've already mentioned. Okay, now something that is also very important to note is that in a controlled tenancy, the landlord is allowed to terminate the the lease agreement or the tenancy agreement on very specific grounds. The landlord cannot just terminate anyhowly. There are only specific grounds that the landlord will be allowed to terminate the tenancy agreement. The first one is where the tenant has refused to repair. The tenant has refused to repair the internal walls. Remember that the duty to repair internal walls are for the tenant. So if the tenant has refused to commission the repairs of internal walls or whichever is part of his obligation under the tenancy agreement, then the landlord is allowed to terminate. That is the first one. The next one, if the tenant does not pay rent for a minimum of 2 months, if the tenant does not pay rent for a minimum of 2 months, not 1 month, and that is also a warning to those landlords that are here. Rent ya 1 month usipigie mtu kelele sana hivyo. Let the tenants breathe. Okay. Kama mtu hajalipa rent for 1 month, tulia kidogo. Don't chase them away because of 1 month rent. So in as far as controlled tenancy is concerned, it is just 2 months. 2 months, at least 2 months. If they're not paid rent for 2 months, then that is a ground to terminate the lease. Okay. If the tenant has breached any obligation, remember we said this, any obligation, breach of any obligation within the contract. So if the tenant has breached any obligation within the agreement, then that becomes a ground to terminate the lease or the tenancy agreement. Okay. The other instance where the landlord is allowed to terminate the agreement is where the landlord is providing an alternative accommodation. an alternative accommodation that is reasonable and acceptable to the tenant. So if you're terminating and you're giving the tenant another accommodation somewhere, okay, in another place, then that is a ground for termination. So if you're providing the alternative accommodation, you are removing them from house number 1 and to house number 20, that is a ground to terminate that specific lease agreement. And then we have demolition and reconstruction. So if the landlord is intending to demolish the property to reconstruct it, okay, then the landlord is allowed to terminate the lease or the tenancy agreement. And then lastly, if the landlord himself is intending to occupy the specific property. So if the landlord is willing or is intending to occupy that property himself, then he can terminate. But of course, same grounds. You provide a notice for 2 months, and then either party that is aggrieved will go to the BPRT. Are we together? Now that is the controlled tenancy in as far as hotels, shops, and catering establishments are concerned. Now, lastly, let me just mention the one for the Rent Restrictions Act. Now, under the Rent Restrictions Act, the Act creates a tribunal called the Rent Tribunal. Okay. Now, the Rent Tribunal is a tribunal that is in charge of handling disputes between landlords and tenants of residential houses whose rent does not exceed 2,500. Okay, so this is mostly for the low income zones. Yeah, there's a lot of places in Kenya where people still pay rent that is less than 2,000 or 2,500 and below. So if one falls within that category, then that is a controlled tenancy, and the tribunal will take control of that tenancy. And the reason is very simple: we are trying to protect the right to housing of the low income population. So that is a controlled tenancy in as far as that is also concerned, but not really as specific, not within the meaning of the Act. The Act only relates to hotels, shops, and catering establishment. But outside the Act, we also have the Rent Restrictions Act, which now provides another kind of tenancy that is special in its own nature, which is a tenancy for residential houses where the rent does not exceed 2,500. Okay, and the jurisdiction has been given to the Rent Tribunal. What are the powers of the Rent Tribunal? Again, the Rent Tribunal will do everything that the BPRT can do. They will fix the rent, they'll fix the service charge, they will decide whether it is controlled, they will decide on termination, they can order repairs, they can summon parties, they can order payment of compensation, payment of damages, payment of cost, they can inspect, and all that. Okay, so those are the powers of the two tribunals that are the same, and those are the two types of tenancies that will fall under the quote-unquote control tenancy. So the first one is very specific and very special. That is tenancy for a shop, hotel, or a catering establishment. Guys, tuko sawa? So let me take questions. Kiptong Eno.
Yeah, Mwalimu, I had a question. There's something I missed on as to appeals from the BBRT. You said if you are dissatisfied with the ruling, you can appeal to which court?
That is obvious, my friend. That is not even a question. What do you think? Tell me. Which court do you think you should go to? Ngeno?
Kindly educate me on that.
I can't educate you on that, my friend. BPRT. Okay, BPRT. What court do you think you can appeal to? Is a tribunal. Which court do you think you can go to? You don't have a lot of courts, so you can gaze all of them until you get to the right one.
High Court?
No, the High Court. Ngeno, unmute your microphone and speak.
Magistrates?
No, my friend.
Unless you guide me on that.
No, I don't want to. I want you to guide yourself. So it's not the High Court, not the Magistrate Court. Next. Ngeno, next. Ngeno.
Okay, I'm blank on that.
You can't be blank, my friend. What do you mean you're blank? Court. Just mention courts. You don't know courts. Which courts do we have? Structure of courts, hierarchy of courts. You mentioned magistrate courts. No. High Court. No. You've forgotten all courts now. You don't know any other court now.
ELC branch of the High Court.
ELC is not a branch of the High Court. What do you mean?
ELC division, not division per se.
It's not a division. So give me the hierarchy of courts. Start from the top to the lowest.
Supreme Court, Court of
Yes.
Appeal. Then now the High Court. Then magistrates and the High Courts and courts of equal status, and then now the magistrates. And then tribunals, magistrates and tribunals.
What do you mean, my friend? There's a court you're leaving out. A very important court. After the magistrate court? After the magistrate court? Ngeno Kipto, ngeno.
Yes. After magistrates, we now have the tribunals.
Where are you? Let's start there. Uko wapi?
Ngong Road.
Ngong Road is very big. Ngong Road is too huge. Narrow it down.
Race course.
Yes. You need to race. Anyway, what is the last court, my friend? Are you serious now? Like right now, you're serious. What is the last court? After magistrate courts. Before you get to magistrate court, which court do you start from?
Someone can assist me from there.
Which one? Nobody will assist you. Nobody will assist you. It is you that will assist yourself. My friend, if I have a matter that is below 1 million shillings, where do I go to?
The small claims court.
Do you drink something? Are you getting drunk right now?
No, I'm sober. What's up?
And why was it taking you too long to mention small claims court?
Sorry about that. It escaped my mind.
Stop partaking something. So guys, yeah, so that is what you're saying. So the same way you highlighted them very clearly from the top to very bottom, and to the High Court, you've clearly said that they are courts of equal status. So when a court is of an equal status, it is not a High Court, it is not a branch of the High Court, it is not a division of the High Court. It is a special court, and that court is the ELRC and also the ELC. So because this is a land question, we are in conveyancing. This is a land question dealing with houses. It is not a commercial court that goes to the High Court. Neither is it an employment court that goes to the ELRC. It is a land question that goes to the the Land and Environment and Land Courts. So that is the ELC. So when you are not happy with the decision of the tribunal, you appeal, not judicial review. We talk about this in civil, but not judicial review. It is an appeal to the ELC. All right. Any question? No question? All right, guys. So that is the end of control tenancies. That is the end of control tenancies. That is the end of leases and everything on leases. The next discussion is on sectional properties. But I want us to look at few past papers on what we've discussed before very quickly, and then we can start on sectional properties in the next class. After sectional properties, we'll have charges. After charges, we will talk about rights in alieno solo. But before that, we'll talk about taxation, stamp duty, and CGT, and then community land, and then we'll just be summarizing on everything else that is in the course outline that we have not talked about. Things to do with conversions, extensions, renewals. So everything else will be done. So once we're done in sectional properties, we'll be doing taxation, and then we do charges. Taxation is a 2 minutes thing. So anyway, any question on leases first, guys? Any question on leases? Sandra Njau.
Say that a control tenancy can be terminated, an agreement can be terminated where the landlord is providing an alternative accommodation reasonable and acceptable to the tenant. Does that mean that if, for example, the landlord takes the tenant to another accommodation that is owned by them, a new lease agreement comes into place?
Yes. Remember, if you're staying in house number one, and the landlord takes you to house number B, the tenancy agreement for house number one is terminated. What did we say? We said, what is a lease? What are the elements of a lease? Defined parties, defined property. So the property must be defined. The moment you're leaving house number one, the property is changing. Therefore, that lease agreement for house number one expires. And therefore, when you get to house number B, it is another agreement is coming in place. So most parties don't consider that. They just move into new houses. They just agree verbally with the landlord to move from house number one and house number B. You don't understand the consequence. The consequence is the lease agreement for first house is now terminated, because when you come up with a lease, it is for a defined property. House number one is different from house number two. Are you together? So that is exactly why those two lease agreements will not stand. Are we together? Say something. Guys, can't hear you.
We can hear you, Mwalimu.
You guys are not saying anything. Am I muted? All right, sawa. All right, so let's go and talk about the question that is on your screen. Can you see the question on your screen? Can you see the question on your screen, guys?
Yes, we can see the
Yes,
question.
we can.
My goodness. All right, so somebody read for us the question. So guys, as you read the question, I want you to do this thing. Do this. Take a notebook and a pen and note down everything that is maybe something you remember from our discussion in the question paper, or something I've not mentioned on leases, or something that I've not mentioned. You just remembered about it right now. Guys, ask as many questions as you can. Guys, I keep saying this and you guys don't even take it seriously. Ask as many questions as you can. The easiest way to track your questions is to note them down so that you don't forget about them. So as we discuss the questions, there's something that this question might remind you of. take note, write it down, and then you ask it. Don't walk out of this class with something that it is not making sense and you're walking out with it not understanding it. That is unfair to yourself. So ask. There's no excuse of I'm shy. If you're shy right now, even the examiner will be very shy when it comes to giving you the marks. The examiner will be very, very shy with the marks. So please ask every question. Ask. So I want somebody to read for us that question. Okay. Read for us the question so that we can try understand what the examiner was looking for in this question. That is the March of 2023, last year. Nobody wants to read.
Question 2. Sorry.
Okay.
Prime Property Limited is the registered owner of the leasehold property known as LRS/500/12998 located within Nakuru City. The property is located in a busy part of the town, undeveloped and well fenced with barbed wire. The annual rent payable is peppercorn on demand and is for a term of 99 years from 1st November 2001. The company has been approached by Albert, who proposes to utilize the said property as a parking lot. The company approaches you for legal advice on the transaction and has informed you as follows. 1. The company is hesitant to have the use of the defined premises for a period in excess of 1 year, but may be subject to renewal for a similar term. 2. The company prefers that Albert collects the daily parking fees and deducts an agreed commission fee from the revenue collected. 3. The company prefers that Albert maintains the parking lot in a good condition for the entire period and keeps proper records and books of accounts at all times. A. Explain the possible ways that you may consider in structuring the transaction between Prime Property Limited and Albert, noting the pitfalls of each one in protecting the interests of the company.
Perfect. Thank you for reading clearly. Thank you very much. Now, guys, you've seen the question. So the first thing you want to do in every question, guys, the first thing you need to do in every question, anytime you are answering a question, the first thing you run to understand is who are the parties in this question? Who are the parties? So we have the first party is Prime Property Limited. That is the owner of the property. Okay, located within Nakuru City. Okay. Number 2 is somebody called Albert. Okay, Albert is intending to use the property as a parking lot. Okay, the next thing you need to understand is who are you representing in this question? Who are you in the question? So who is your client? So our client in this case is the company. Why is the company your client? Because it is a company that has approached you for legal advice, not Albert. So sometimes you might have some advice for Albert, but don't advise Albert in this question. Albert is not your client. Okay? Your client is the company, and the company is the one approaching you for legal advice. So that is the first thing you understand. Understand who the parties are and who among the parties or between the parties is your client. That is the first thing. The next thing is, what is your client looking for? What is the interest of your client? Your client is, what is the client telling you? What do they want you to achieve? So debunk your thoughts, your advice, what you think, your opinion, or what you think is best from your mind, and stick to what your client is looking for. So that is the first thing. Who is your client? Number 2, what is your client looking to achieve? Then you go to the question. So what is the first question? Now, this entire transaction. Explain 2 possible ways that you may consider in structuring the transaction between Prime Properties Limited and Albert, noting the pitfalls of each one in protecting the interest of the company. Okay? What is... So before you answer this question, you have to come back to the pointers, what the instruction. The company is hesitant to have the use of the defined premises for a period in excess of 1 year, but may be subject to renewal of a similar term. What is the meaning of that? The company is telling you, we don't want this person to have this property for more than 1 year, but we are open to have 1 year and keep renewing it for 1 year, 1 year, 1 year. Number two, the company prefers that Albert collects the daily parking fees and deducts an agreed commission fee from the revenues collected. So Albert collect the fees, and then from that fees is the commissions are deducted. Okay? And then thirdly, the company prefers that Albert maintains the parking lot in good condition for the entire period and keeps proper records of books of all accounts at all times. Now, based on what your client is telling you, what do you think your client should do? What are the two possible ways of structuring this transaction? Do they need a company? Do they need a partnership? Do they need a charge? What do they need in this question? Put up your hand, guys. 4 marks, 4 free marks. Guys, this question is not hard. Not hard. Very, very simple. What do they need? Ala. Niko inchi gani bwana? Niko inchi gani hii? I can only see 2 hands. Let's start with Wamboi. Wamboi, talk to us.
An attempt,
Mm-hmm.
I would say, would go for short-term lease
Mm-hmm.
as the first option.
Mm-hmm.
And the second option would be controlled tenancy.
Wewe. Unanisikia? Umenisikia?
Yes, mwalimu.
Perfect. So, kama unanisikia, let us start from the first one. So, the first one is okay. The first one is fine. The first one is a lease, a short-term lease. Okay. The second one is what? A tenancy is a lease. A tenancy is a lease. A control tenancy is a lease. And why do you want to? Why do you want it to be a control tenancy? Because I need to send people to trace you in your entire lineage to deal with you. Why do you want it to be a control tenancy? Let's start there. Maybe you have a point that we need to all look at. Share with us, Council.
Why I would say control tenancy
Mm-hmm.
is because of section 3. 2.
Mm-hmm.
We have it can be reduced into writing for a period not more than 5 years, and it contains a termination clause of not a termination clause, sorry, it is reduced into writing, but for a period of not more than 5 years. Yes.
Okay. I'm projecting it for you there. Guys, this is how marks disappear. If you too. I'm projecting it for you again, Wakili Wamboi. Tell us. So what is a control tenancy? Read for us on your screen.
Control tenancy means a tenancy of a shop, hotel, or a catering establishment, A, which has not been reduced into writing, or which has not been reduced into writing, which is for a period not exceeding 5 years, or contains provision for termination otherwise than breach of covenant within 5 years from the commencement thereof,
Mm-hmm.
or relates to premises of a class specified under subsection 2 of this section.
Leave alone that. Fine. So do you want to change your answer? Why do you think the question talks about a control? It is a control. Why would you think it is a control tenancy? I
think I would take back control tenancy because of the definition.
Before you take it back.
Okay.
What in the definition is making it not to be a control tenancy, so that everybody else will understand? Because the moment you say control tenancy, there are people that have already cramming that one and putting it down in their notes. So why do you think it is control tenancy, or why do you think it is not?
Okay, I would say it's not because of the definition where it says it can either be a shop, a hotel, or a catering establishment.
Exactly. Guys, wake up. Guys, there is no control tenancy if it is not a shop, hotel, or a catering. It must be for a shop, guys. I've said this, that there's a reason why these specific tenancies are being controlled by the government. A shop, hotel, or a catering establishment. So it doesn't matter if it is at least for 5 years or less. It doesn't matter. So long as it is not for a shop or hotel or a catering establishment, that is not a controlled tenancy. Now, for it to be a controlled tenancy, it must be a shop first, hotel, or a catering establishment. So if you go to the question, if you went to this question and you are told that Albert, let's go back to the question. Okay? Albert is trying to get this property for purposes of using it as a restaurant. Let me project again. If the question was telling you, where's my question? My question has disappeared. Hey, Mushiri Brand, wewe lazima sasa nikutafute. Wewe lao nakutaka sana. Ulale ndani. Wewe lazima ukuwe mgeni wa serikali. Here's my question. My question has disappeared. Wewe lazima ulale ndani. Anza kupack bag yako. Mushiri Brand. There. Can you see the question? All right. So if the question was saying that Albert proposes to utilize the property, let me highlight that for you. Okay. If the question was saying that Albert is trying to utilize the property as maybe a restaurant or hotel or a catering something, then the first thing you'll be noting is this could be a controlled tenancy. Hotel, shop, or a catering establishment makes it a controlled tenancy. You start there. Okay, you start there. And then you go and ask yourself for what term, for what period. And then if it is for less than 1 year, then that could be a controlled tenancy. Okay? Are you together? All right. All right. Sawa. You understand that? You understand that? You understand that? Now let's go back to the options available. Guys, this is not a partnership. I was just mentioning a partnership as a joke. Some of you took it serious. Some of you saying short-term and partnership. Guy, there's nothing like that. Okay, so it is a lease. The first instance is a lease. It can be a lease. It is a lease. Okay, it is a lease. The term notwithstanding, the first option is a lease. What is the second option, guys? Rachel.
Mwalimu, this is not, I have a bit of a question about what you just said.
A question. You can ask a question now.
I'm
answering the question. I want somebody to answer this question.
Mwalimu, is it a lease or a sublease? That was my question. Because if you look at the question at the beginning, the people who own this property already own it in a lease. So is it a lease
or a sublease is the same thing.
Okay.
A lease and a sublease is the same thing. It's the same thing. A grant of exclusive possession over your property. It's the same thing. So whether you say it's a lease or a sublease is the same thing. Somebody to answer this question, guys. Guys. Kimaru.
Mwalimu, I would say it's a license. Yes.
Thank you. Guys, this is a no-brainer. Guys, this is a very simple thing. It's obvious, guys. It's obvious. When you're given a transaction, the examiner is trying to understand whether you understand the different transactions when it comes to leases. The first one is a license. And that is why at the very beginning, we discussed the difference between a lease and a license. So you can structure this transaction as a license. And we've discussed this. And even the fact that they have mentioned a parking lot, it's supposed to bring something to your mind like parking lots are usually licenses. When you go to town and you park, you're just getting a license to park. Okay, a parking license. Okay, you're just getting a license to park. So it can't be either. It can be a lease or it can be a license. This question is simply asking you to discuss the two possibilities, that is a lease and a license, and what is the shortfall of each in trying to protect the interest of your client, who is now could be the licensor or the lessor. Okay, what is the shortfall of? The shortfall of each. So a lease and a license, not a company, not a partnership, guys. Focus. So it's a lease and a license. Thank you so much. So now that it's a lease or a license, what are some of the shortfalls of each? Okay, and what are the shortfalls of a lease? Let's start there. Shortfalls of a lease. The disadvantages of having a lease in this instance. What are the disadvantages? Guys. Rachel?
That was an old hand.
What do you mean? You've grown old, or your hand is just your hand? Has your hand aged? Not. Guys, what is leases and licenses, guys? Leases and licenses, okay? Now, when we're discussing leases and licenses, there's the difference between a lease and a license, okay? The difference between a lease and a license. With that at the back of your mind, why should somebody take a lease and why should somebody get a license? For instance, the difference between tea and alcohol. If the options, the options are, if you come to this office, you are going to get a glass of alcohol or a cup of tea. But first, what is the difference between a cup of tea and a glass of alcohol? Alcohol will do this, tea will do this. Now, if your client is looking at, they're asking you, I'm going to that office, but I want to either take alcohol or water. What are the shortfalls of each? It's the same thing. Same thing, guys. When they go for license, what is that? When they go for a lease, what is that? It's the same thing, guys. Do not overthink this question, guys. Let's agree. Don't overthink the question. Convincing questions will give you a lot of room to overthink, but don't overthink. Don't be tempted. Don't follow the examiner into the pit hole of overthinking. Don't let them take you there. Just read the question the way it is. Leases and licenses. The difference between a lease and a license is this. Now, from that difference, which one has a disadvantage? Which one has an advantage? That is exactly what the examiner is asking you for 4 marks. Guys, can you guys get that? Sanita. Let's start with Sanita Vivian.
Why my client should opt for a license instead of a lease is because the process for transfer of lease is more complex than license.
That is not the question. That is not the question. The question is, guys, and don't answer your own. The question is, explain 2 possible ways Okay, so how are you going to introduce the answer? The following are the two possible ways that the company will consider in structuring the transaction. The first one is a lease. You write one, a lease. And then you'll be saying that the first option the company can consider is having a lease between the company, the Prime Property Limited, and Albert. Okay, and then you write shortfalls of a lease. And then two, license. The second option is a license with Prime Properties Limited being the licensor and the Albert being the licensee. Shortfalls of a license. Equal to, so you're not picking one over the other. You're not picking one over the other, but you pick a list, you give us the disadvantages of, if your client was to go for a lease, what are the disadvantages? If your client was to go for a license, what are the disadvantages? Sanita, tuko na wewe?
The disadvantage of a license compared to a lease is that it's more short term. In the instance where a business would wish to have to conduct its business for a longer time, then a license would not be advisable.
You've changed, you started the lease. The question, you don't want to answer my question, you're just answering yours. Your first option is a lease. What are the shortfalls of a lease? That is the question. What are the shortfalls of a lease? If your client was to go for a lease, what are the shortfalls of a lease?
The process of transferring the lease is more complex than it has context.
Wait, who told you they don't want to transfer any lease? They're not. Are they transferring any lease? They're not. Anyway, Natwati Robert Kisangani. Thank you, Vivian. Natwati Robert. Guys, don't import this point. They're just the things that you know. They're just the differences that you know. We discussed them. One.
I think license does not give.
You're not answering my question, Robert. You're not answering my question. You're just answering yours. I'm asking, when your client comes to your office, they want to get 2 points. I mean, 2 options. You've given your client the 2 options. The first option is a lease. The second option is a license. So we started the lease and we're saying, what are the shortfalls? What are the shortfalls of a lease? If your client was to go for a lease, what would be the shortfalls? Shortfall number 1 of a lease.
This is technical.
No, it is not technical, my friend.
Okay. The shortfall, maybe let me try. I'm just imagining the shortfall number 1 would be a lease must be registered. That is the process.
Natwati Robert Kisangani. Unajua najua mpaka kwako. Tatumana mtu huko. What do you mean? Short-term leases are not registrable interest in land. This person wants a short-term lease of 1 year and not more than 1 year. They're not registrable interest in land. Guys. Omar Tanzila, talk to us.
The shortfall of a lease is that a lease confers more rights to a lessor, so it will confer, to a lessee, so it confers more obligations to the lessor.
Every party has their obligations. Every party will have the obligations. It does not confirm more. Every party has the obligations there.
As compared to a license?
I mean, if what are the shortfalls now? When you talk about a lease in terms of if your client will speak a lease now, okay, what are the shortfalls of having a lease in this question? So you're saying the obligations that as compared to a license, the lease will confer a lot of obligations on the lessor. I can let you go with that.
Yes.
Yeah. I can let you go with that.
For example, can I give an example? that the lessor will have to, like, he has a duty to repair, and then we were told that the state of repair of the building and the whole parking lot, it's in disarray. So I was tying it up to like the beginning of the question. So it's going to have to repair, and then there's fitness for human habitation. So I was thinking of how to tie it with the narration in the question. So that's one point.
What do you
and
mean
then the
fitness
second,
for, wait, what do you
Yeah.
mean fitness for human habitation?
Well, that's an obligation of the lessor, right? To
How relevant is it in this question?
Not very.
Not at all. This is a parking lot. Nobody stays in the parking lot. So there's no human habitation at the parking lot. Guys, you guys are overthinking this question. Don't overthink this question, guys. So the first point you can say is fine. A lease will confer, as compared to a license, a lease will confer more obligations on the lessor or on the parties, or comes with more obligations, the implied duties and covenants. That is a point. What is the next point? Alphonse. Let's hear from Alphonse as well.
Yes. Yes, I'd say that the second one will be a lease cannot be revoked at any time because it's a contract. So it's a contract for a defined period. And until that period lapses, you cannot just revoke it anyhow, or else it will be a breach of contract.
Exactly. Again, perfect example, a perfect point. So just go back to the difference between a lease and a license and convert those differences as advantages or disadvantages. One disadvantage is a lease cannot be revoked. So the fact that this cannot be revoked, if you're not happy with Albert, you can't revoke the lease. Okay? A lease cannot be revoked. A lease cannot be revoked. So you have to wait until the term of the lease has expired. So that is a point. What else? You just needed one or two. We have two. What is the third one? Larion? Diana, Kipsuge? We can't hear you, Larion. We can't hear anything you're saying. Your microphone is on, but we can't hear anything.
A lease
Diana?
confers exclusive possession, unlike a license.
Yes, a lease will confer exclusive possession. So if you give this person a lease, just be sure that you're going to give them exclusive possession. Okay? Guys, you're just translating the differences to become disadvantages or advantages, guys. There's nothing to be thought, to be overthought about. Normal things. A lease confers exclusive possession. So you as a company, if you want to become the lessee, just make sure you know that when you give Albert a lease, Albert will have exclusive possession over the parking lot. Alingo, Penina, is there anyone to add?
Okay, Mwalimu, a clarification, not a clarification, but guidance. But I would state that a lease now confers an interest in that property, while now a license only creates.
You said a clarification or a guidance? What you say? Two things.
No. It's just I wanted to state my point and then seek your guidance from there.
So the point is?
The point is, in this, our client going by a lease is that a lease, it creates an interest in that particular property, while a license only creates a personal right to use that particular property. So in this instance, is if Albert will be, if they go via a lease, then it means Albert will have an interest in that particular property, that lease property. Yes.
Perfect. All right. Thank you so much. Siror, Joseph?
Yeah, Mwalimu, from the question, it would appear that the owner wants to be able to collect some commissions out of the parkings and also would require Albert to maintain some records for the same reason. This can only be accommodated in a license rather than a lease, which would have given him exclusive possession and the use of that person. Thank you.
That could also be a very good point, an amazing point. So guys, like I've said, like you've seen, like I've said and you've seen, there's nothing that is coming out of anywhere that you've not learned. You have the points. You're just not thinking that they are the points. Those ones are the points, okay? Don't think out of the box that those ones. Now let's go to the license. What are some of the disadvantages of now having a license on the part of the company? Don't overthink it. 1 or 2 points enough. We move. Michael Okile, let's start. If it is a license, what will be the what will be the issue?
The advantage of
one has already been said.
I think another advantage of a license is that
where you're answering your own question. What is the question? The shortfall of a license. If they're supposed to go for a license, what will be the disadvantage? Not the advantage now. Disadvantage of a lease, disadvantages of a license, the shortfall of each. Okay, so we are talking about the shortfall of a license. If it was a license, what would be the challenge? Guys, read the question and internalize. Don't be in a hurry.
So one of the other disadvantages is that they will be limited in the activities that they'll be performing under that particular license.
Like what activity?
For instance, if it's a license to park their vehicles there, they'll just be parking their vehicles there, not maybe open a car wash.
No, but they've said they just want to park. They don't want a car wash. They just want to park. It will be used as a parking lot. That is what the question is saying, that they are intending to use it as a parking lot.
I think that's the thing that I've said. They'll just be limited to using it as a parking lot under that particular license, unlike if it were a lease.
How is that a disadvantage to your client? Who is the company? Guys, I've said know who the parties are, who your client, and what your client wants. Now, your client is the company who is the owner of the land. How is that going to be a disadvantage to them? So make it a disadvantage to the company, to the client.
If I may try, the company will be disadvantaged in that they'll just be able to use their particular piece of land as a parking lot under the license.
But that is exactly what they want. They just want to use it as parking. They're giving it out as a parking lot.
I think I'm defeated on my end, but however, just saying it that they'll be limited in that they'll use it as a parking lot, and they will not be able to venture into other activities in relation to the parking lot.
I've said again and again that is not what they want. Is a parking lot. They want to use it as a parking lot. So why are you assuming that they want to do other things? The question only says, which I've highlighted there, Albert proposes to use the property as a parking lot. And then the points that point 1, point 2, point B doesn't want anything else done, just the parking lot business. So that becomes, that is not a point in that sense. Let's talk to Wakiaga. What do you think will be a disadvantage if they're supposed to pick?
Well, my client has indicated that he would want Albert to maintain the premise, but a license does not confer that kind of obligation on the part of Albert.
Yes, a very good point. Remember, a license is the permission to use. Okay, a license is just the permission to use, not to maintain. Okay, the condition. So if you want it, the condition to be maintained, that would be a lease. Perfect. So a license does not confer the duty to maintain as compared to what a lease would. So a lease would be more perfect in that sense. So the disadvantage of a lease in this instance is because whereas your client is seeking to have the property maintained, the license does not confer that kind of obligation on the licensee, the holder of the license. Thank you very much. Somebody already mentioned something. I've forgotten her name. About the short-term nature of licenses. Licenses are for short-term purposes. So if your client is trying to get something that is more of permanent or on a renewable basis, then you will need to have a lease, not a license. Omoi Kefa, what else do we need to have as a disadvantage of a license?
The licensee will not have any obligation to be accountable for revenues raised from the property to the licensor.
How do you mean?
From the question, my client requires daily records for all the revenues raised or fees raised from parking, but under the license, that may not be an obligation of the licensee for the time he's using that facility.
It can be, and it is an obligation. It can be. When you give a license, you can always have that obligation as part of the license in terms of commissions and the license fees. That is part of the license. Omwenga?
License does not give an interest in land, and therefore Albert can wake up one day and decide to terminate the agreement before the 1 year.
When you say interest in land, that will only be it will be an advantage to the company. It will be an advantage to the company because now the company is the one that owns the land, and therefore if Albert cannot have an interest in land, then that is an added advantage to the company. Elizabeth, Miss Elizabeth.
Will be liable to pay the county rents and the government, as in the government rates and rents during the period.
Who will be liable to pay the rates?
The company, if it's a license.
But no. If it is when you have a lease, remember when you have a lease, the holder of the lease here is the company. The company is already paying the rates and rent. Either way, the company is already paying rates and rent because this is a lease. So when they create a sublease on the property, like they are trying to create to Albert, it's not even a sublease. Okay, so when they do that, because we're looking at both instances. So if they go for a lease or a license, that doesn't change any rates or rent obligations. You get what I'm saying? So they will still be paying that. That will still be payable.
Okay.
Regardless of whichever side they decide to go, they will still pay that.
But if it was a long-term lease, then it would have been different. Just a follow-up.
No, even if it was a long-term lease, it will, unless they transfer the lease to Albert entirely, then they'll transfer the obligation to pay the government to Albert. So right now they're still paying. Okay, like right now, the place that you're staying, if you're renting, your landlord, if it is a lease, the landlord is still paying the government rates and rent on that land. But when you pay your rent, that is not part of the. You don't include. You don't pay rates. That's what I'm saying.
Okay, understood.
All right. All right. So guys, that answers the question. Let us go to the next question quickly because of time. Let us go to the next question because of time.
Shit, come on. Ni nini unaona hapa Dolo unakaa?
Wewe. Zima. Mute your microphone, please. So let's go to the next question. I'm trying to get the question. All right, so this is the next question. So question B, explain how you'd go about the transaction to ensure that it is not a controlled tenancy. 3 points, give me 3 points. 3 points to ensure that this is not a controlled tenancy. We are not saying it is. We are not saying it is, but you can make it a controlled tenancy. You can make it a controlled tenancy. But now what did you do to make sure that it is not a controlled tenancy? We are not saying it is, but we're just saying, how can you go away from controlled tenancies? Point 1. Put up your hand, guys, quickly. The first one. Let's talk to guys, people that are most. Anyway, Rachel, let's start with Rachel.
It has to be for a period longer than 5 years.
Yes, that will be that will be the first one. Actually, that will be the second one. What is the first one? Yes, Owino, Eric.
Yeah, so you reduce it into writing, and which is for more than 5 years, and then we can also include. Yeah, we can also include a termination clause or on a breach of contract termination clause within it.
Termination clause for breach of contract. Remember that it must be for a breach of contract. What is the next one? The third point. Paris. Paris is not there. Muigai is not there. Wakega Robert.
First, by ensuring that the premise is not leased out to a shop, hotel, or a catering establishment.
Yes, that is the first one. You make sure that the use of the property is not for a shop, hotel, or a catering establishment. The use is not for a shop, hotel, or a catering establishment. Okay? Then the second one, it must be in writing for a period of 5 years, and then it contains a clause for termination of the agreement for breach. It must be for breach, not for anything other than breach. For breach, that is how you make it escape the jurisdiction of controlled tenancies. The last one is Albert requires rates and clearance certificates to be furnished before you can proceed with the transaction. Advise your client on the import of the statement. Okay. Now, these are completion documents. They're really completion documents when it comes to transactions. So I'll just explain it and it applies to both. It applies in both instances. So the first thing you need to understand is that every proprietor of a lease is required by law to pay to the government, that is the county government, rates and the rent. Okay, so that obligation is stated in law. So the first point is that every proprietor, because the company is the proprietor of this lease, the company is liable to pay to the county government the rates and the rent. If it is a freehold property, just the rates. If it is a leasehold property, the rates and the rent. Okay, now in this case, it is a lease and therefore it is both the rates and both the rent. Okay, now as a person that is taking the property on a lease, if it would be a lease, then Albert must be sure that the company has paid the rates, the accrued rates and accrued rents, the accrued rates and accrued rent. Okay, and therefore they will have to provide or document by provision or evidencing the rates clearance certificates and the rent clearing certificate as evidence that they have settled the rates. Now, the advantage of that, the importance of having those clearance certificates is so that the government does not interfere. Okay, the government does not interfere with Albert while using the property. The government does not interfere with Albert or does not interfere with Albert's enjoyment or operations of the property just because the rates have not been paid. So it's a standard rule that applies to all instances. In terms of even transfers, when you're being when you're representing the purchaser and you're being told to advise the purchaser on the import of rates and rent clearance certificates, you start from the point that every vendor must pay. Every owner or proprietor of any lease or land must pay the rates and the rent if it is a lease, or the rates if it is a freehold. Okay. Now, the purchaser is entitled to have the rates clearance certificate as evidence, as completion documents, and as evidence that the vendor or the owner of the land has paid the rate, so that their quiet enjoyment of the property is not interfered with by the relevant county governments. That is the import of that statement. That is the import of that specific statement. Are we together?
Yes.
All right. All right. So this other, any question? So let's go to question 6. Somebody read for us question 6 of 2019. Question 6. You can start there. We'll just get over them quickly because the things we've discussed before. Somebody read quickly, guys. Time. Wendy. Guys, somebody read.
Can I read?
Yes, proceed.
Wendy and Lucia are a mother and daughter owning property LR number 209/1449. Erected on the property are godowns for letting. Lucia and Wendy had commenced negotiations for a lease with Valentina and even executed ahead of terms for one of the godowns. Unfortunately, Wendy
read loud, my friend. Increase your volume.
All right. And unfortunately, Wendy suffered a stroke and died prior to registering the lease. She had not even signed the lease at the point of her demise. Lucia allowed Valentina to occupy the godown owing to the cordial relationship she had with Lucia's late mother. Soon after Wendy's burial, Lucia forwards Valentina a duly executed lease executed by Lucia and attested by her advocate for execution in return for registration. Accompanying the lease is a copy of certificate of title for the property dated 30th May 1998. A. Advice Valentina on the registrability of the lease document. B. Compare and contrast a lease to a license. And C. Identify at least 4 express and implied covenants that a prudent advocate would consider incorporating in a lease document when acting for the lessee.
All right, guys, these are easy things, so we can just shout them out. There's, like I've said, exam questions on leases are just as basic as anything. There's nothing else. There's nothing the examiner can do to hide the question. They're just there. They're just normal things. So Wendy and Lucia, the owner of that lease, that is LR number 209/1449. I've said LRs are leases. You remember that? So erected on that property are godowns for letting. So Lucia and Wendy are commencing negotiation for a lease with Valentina. Okay, and of course executed a lease agreement. Unfortunately, that person died, and therefore they did not sign the lease. She had not even signed the lease at the point of her demise. Now, the main point is here. Soon after Wendy's burial, Lucia forwards Valentina a duly executed lease executed by Lucia, okay, and attested by her advocate for execution and return for registration. Accompanying the lease is a copy of certificate of title of the property dated that. So, in this instance, what do you think? Mm-hmm. Let me see hands. So advice on registrability. Registrability. Guys, we talked about this. It's a very small concept. It's a very small concept. It's a very, very small concept. Guys, it's a very, very small concept. Please explain it to me. Tell me. Guys, what is the concept here? Yes, Robert Kisangani Natwati.
Mwalimu, the concept is all instruments of transfer must be signed or executed by all parties. So if one of the parties have not executed or signed the document, then that document cannot be registered.
Okay. But there's no transfer here. There's there's just a lease here. There's no transfer.
I'm not talking about transferring, but I think they are talking about registration.
But you said all documents of transfer must be signed.
No, I'm saying the concept of both parties executing the lease.
But that is not they've signed. Listen, they have signed. Lucia has signed, and she has forwarded to Valentina to sign. So both of them will sign. I've highlighted a few things there. I've highlighted a few things on the question that you need to understand. Guys, somebody tell me, what is the point there? Guys, we said this. I say this all the times. I said this all the time. Somebody, what is the issue there? What is the issue this question in terms of registrability? Can they register this lease? Okay, can they register this? Can it be registered? What needs to happen first? Guys, yes, Siror Joseph.
I think the issue that Wendy and Lucia were jointly owning would indicate that survivorship would kick in and Lucia would actually become the owner. So I think she would have the powers actually to execute it as she would be the rightful owner.
You are close home, but you're not coming through the gate. You're coming through the window. You're close home, but you're coming through the window. Get it through the gate. What is the issue then?
The issue here is transmission.
Who is that?
Oh, my hand. Let me pull my hand up again, Mwalim. This Kisangani.
Proceed, Kisangani. Proceed.
They are joint owners. It means if one person dies, then the other person becomes the owner of the property. So it can be registered because the property was owned by Wendy and Lucia. So if one person dies, that is by transmission. That is, she gets to own the property without the normal way of transferring it. It's like involuntary.
There's no transfer here, my friend. There's no transfer here.
It's transmission.
You're not getting the point. There is no. You're right in terms of transmission, but the question is,
yes, Mwalimu,
can this property be registered? Can this lease be registered as it is? Remember, what is the point, guys? You're not seeing the point. I've even highlighted in yellow. Okay? Well, the first point is Wendy and Lucia are mother and the daughter jointly owning this property. Okay? Now, they prepared a lease, but that was before she died. What have I highlighted? She had not even signed the lease at the point of her demise. Okay? It was prepared, but it was not signed. Now, Lucia assigned. Okay? Lucia assigned the lease after the mother died. She has signed the lease and witnessed by her advocate, and she has sent that lease, which was prepared by her mother, to be executed and returned for registration. The question is, can this be registered? Yes or no? Yes, why? No, why? Njau Sandra. Njau Sandra. Njau Sandra, can you hear me? Njau Sandra, can you hear me? Yes, Christo. Can't hear us. Maybe she's not here. Okay, next question. Manga, Janine.
I can try.
Okay.
It's not going to be registered as long as the certificate of title is reading both names, so there need to be substitution for Wendy to be removed, and then now Lucia will be the owner.
So what needs to happen?
Substitution of the names.
What do you mean substitution? Don't even ever use that word in conveyancing. There's nothing like substitution in conveyancing. So use another word apart from substitution.
I stand guided.
You can't stand guided, my friend. What do you mean? What needs to happen? We discussed this in class. What needs to happen? Do you wake up and say, fine, substitute? That's what I'm asking. Tua, Joan, proceed. Tua?
I think what needs to happen is that now Lucia will have to obtain, Lucia now will have to obtain the death certificate of her mother, then present it to the registrar, and then now the registrar will delete the name of her dead mother and replace the name. Can I be heard?
Yes, I can hear you clearly. Thank you.
Yes. Can I be heard?
Yes, you can be heard.
Yeah, so I was saying that now Lucia will have to obtain the death certificate of her mother, present it to the registrar, and now the registrar is going to delete the name of her mother is going now to delete the name of her mother and replace it now with her own name. With that, now the document, now the list can be registered.
All right. So guys, that is the most important thing. When somebody dies, guys, when somebody dies, anytime somebody dies in a question, you are not dealing their property until you do transmission. So there needs to be transmission from the name of both of them to the name of Lucia. So she will first have to do transmission. After she has done transmission, that is when she can sign the lease agreement and then have it signed. Oh, sorry, have it registered. So that was the issue here. That was the issue here. The next question is about. Oh, that is a different question. The next question is about compare and contrast a lease to a license. I don't think we need to discuss that. Unless somebody has a question on that. And then the other question is identify at least 4 express and implied covenants that a prudent advocate would consider to incorporate in a lease document when acting for the lessee. If you're acting for the lessee, what are some of the implied, at least 4 implied covenants that a prudent advocate would consider incorporating in a lease document when acting for the lessee? I want somebody to put up their hand and give me all those 4. Ndungu, Bernard.
2 months before exam you start revision. Uniambie utafail aje? Utafail kweli?
Hawezi fail. You can't fail. Bernard Ndungu.
Mwalimu, that was an old hand.
What do you mean hold hand? Answer the question. What is the question? What is the answer to the question? What are some of the implied duties and covenants? What are some of the implied duties and covenants that a prudent advocate would consider incorporating in a lease document when acting for the lessee? Ndungu?
Yes, when acting for the lessee, one of the covenants that you would include the period for the lease.
Wait. How is that a covenant? What is a covenant? Are you a Christian?
Yes, I'm a Christian, mwalimu.
What is a covenant between you and God? Have you read that?
Yes, in CRE.
So what is a covenant? You read in CRE, hata church uendangi. What is a covenant?
A covenant is it's a binding agreement between two parties.
That's not a covenant. What is a covenant? If I say I have a covenant with you, I have a covenant. My covenant is to do this. My covenant to do this. What is a covenant?
It is a duty.
So what are the duties you will be putting in that? Guys, you're not in this class, my friend. Somebody tell me. Somebody, let's help Bernard quickly. What is the question asking you? Guys, what is the question asking you? The question is very simple, but you need to be very keen. Siror Joseph, what is the question asking? Before you even answer it, ask yourself, what is the question asking you?
No, I wanted to contribute to like the terms, really what that property should be used for, like the boundaries. Maybe that it not be subleased.
No. Those are not the terms. Those are not covenants. Guys, hey, this question is very simple. It's very simple. But you guys would have failed this question thoroughly. What is the examiner asking you first? Before you start giving the points, tell me, what is the question asking? What is the interest of the examiner? Let us go to Paris.
I think the examiner is looking for the implied duties of the lessee.
Implied duties of?
The lessee.
Talia sana. Naona kuna machozi mingi. Kuna machozi mingi sana unataka kuzitoa. You will cry. If you answer that question like that, you will definitely cry. Guys. Banafa.
This would entail duties the lessor would have towards the lessee. So things like quiet entertainment.
Thank you very much. First, let me explain, guys. Guys, I don't know what is wrong. Maybe you're tired. I should let you guys go, but let me say this. Identify at least 4 expressed and implied covenants that a prudent advocate would consider incorporating in a lease document when acting for the lessee. So you are the lessee's advocate. How will you ensure you protect the lessee? You are the lessee's advocate. You must always act in the interest of the lessee. So you need to put something in the lease that protects your client, who is the lessee. So these are the duties of the landlord, the implied duties on the part of the landlord. Okay, to protect the interest. So when you're acting for the lessor, the implied duties on the part of the lessee. When you're acting for the lessee, the implied duties on the part of the lessor. And sometimes you act for all parties, implied duties on every part, or sometimes the examiner is just interested in asking you to give the implied duties on every party. On every party. So guys, You are acting for the lessee. You are acting for the lessee. The examiner did not just say that for the sake. So what are the implied covenants that you will have in the contract to protect your client who is the lessee? Lessee. So what are some of the obligations of the landlord towards your client who is the lessee? The lessor to lessee. That is what the examiner is asking. Now, shout them out. Give me the points. Point number 1. Yusuge.
He has a duty to grant quiet and peaceful enjoyment of the premises of the
Yes,
property.
quiet and peaceful enjoyment of the property. Collins Macharia. Collins Macharia. Macharia Collins, are you in this class? Collins Macharia. Yes, you're that one I'm presenting there. Collins Macharia, that is you. I've highlighted you. Okay. Let's go to someone else. I don't know why you don't want to speak, Collins Macharia. Kamunyu Ndungi.
My hand was not up, but maybe a fitness for purpose. That it has to stipulate the intended use, which will comply with
What are you saying, my friend?
the covenant and implied covenant.
So what is the point? Make the point clear.
Maybe that the property is fit for the intended use. For example, if it's a go down for storage.
Yes. So the first one, the second one you'll have is that the property or the landlord should ensure that the property is fit for purpose. Kiriga, Kevin Kiriga. What is the next one? Mongare Jacqueline. Guys, you don't want to speak or what? What is the problem? Mongare Jacqueline. Millicent Wagunda.
Grant.
Huh?
Non-derogation from grant.
Non-derogation from grant. So again, you will have a clause there that there should be non-derogation from grant. That is, the landlord should always ensure that the adjoining properties do not interfere with the quiet and peaceful enjoyment of the leased property. Let's talk to David Odero. What is something else that you'll have there? Odero, David?
Can you hear me? Good evening.
Yes, good evening. I can hear you very well. Thank you very much.
I think I would also include the lessor should not use or permit any adjoining or neighboring use of land in a way that renders the leasehold unfit or unfit for purpose or for use by the.
That is exactly what non-derogation from grant is. That is non-derogation from grant. Ombai Mfuate. David Ombai. Ombai Kevin. What is the other thing you'll have there?
Can you hear me?
Yes.
You can have the covenant for exclusive possession.
That is peaceful and quiet enjoyment. That has already been said. You guys are not in this class. Give me something else.
Perhaps What else? What is left?
What do you mean, what is left? What have you said? You've not said anything and asking what is left. All right, so let's go to Odipo Esther. What do you think? What guys, you guys are giving me two clauses. Just 2 or 3. Odipo?
I'd say pay the land rent and rates.
Payment of the land rates and rent. You want to ensure that the lessor pays the rent. Guys, we're simply talking about what are the implied covenants on the part of the lessor. That's what we're asking. If somebody is not understanding what we're asking, that is what we're asking. Somebody called Kaburu, Tracy. What do you think?
To repair the external walls of a property.
Yeah, repair the external walls. Perfect. They did repair external walls. Desmond Victor. All right. Owino Eric.
Yeah, we can have suspension of rent where the property has been destroyed, for example, by an act of God.
Yes, suspension of rent. Guys, I have realized that you guys don't understand, or rather you don't want to, or you still don't understand leases, and it is okay if you still don't understand leases. Guys, again, remember, it is okay not to understand right now, but make sure that you understand later. Read, ask questions, guys. You cannot understand it if you don't ask questions. You cannot understand it if you don't ask questions. Now, these questions, guys, that we are talking about right now, these are things that are obvious. You know them. These are things that you know them. It's all that the examiner is now saying when you're representing the lessee. Kizungu tu kidogo kidogo tu hapa na pale, but that normal things that you, registration of leases, registrability of this specific lease, you know, there's transmission there, compare and contrast between a lease and a license. We've discussed this question twice today. Control tenancies, again, we've discussed that question twice. So guys, there are things that you understand, okay? So I will tell you this for sure. It is okay not to know now, but do something about it. Read, ask questions, look at questions. We will be looking at more questions as we proceed, but also make sure that you understand. When it comes to leases, guys, leases are really feared. When you're at the school, the leases are very feared, but there's no reason why you should fear a lease. Okay, so I will tell you as we complete leases. Of course, we'll be looking at more questions as we go, but as we complete leases, I want you to understand the points that I did talk about in terms of leases. Understand the meaning of a lease, instances giving rise to a lease, the documentation in terms of leases, that is a lease agreement, certificate of lease, and the sublease. Understand that. Understand the parties, the lessor and the lessee. Even in this question, you need to understand who the lessors are, Wendy and Lucia, and then who is the lessee? The lessee is. Understand the elements of a lease. What are some of the elements of a lease? The elements of a lease. What goes into a lease? The difference between a lease and a license. And then the implied duties. The implied duties and covenant. And I said, guys, duties of the landlord are the rights of the tenant. Okay, so if you're acting for the landlord, you make sure you argue for the duties of the tenant. If you're acting for the lessee, that is the tenant, you argue for the duties of the landlord. So the duties of the other party becomes the rights of your client. The rights of your client are the duties of the other party. Please understand that. Understand how leases are terminated and understand the remedies of parties during a lease. If we had time, I would take us to another question again in 2021 that now has a question on termination of leases and all that. But again, time is gone. But please, leases are very short. Understand what we've discussed today in terms of control tenancies and the duties of the tribunal. Read them, okay? If you read and you understand and it doesn't make sense to you at all, okay, if you read and you don't understand, and it doesn't make sense to you at all, you are trying to understand, but it's not getting in. You know, sometimes here in Akatatu, you let me know so that we can see how to help. So just let me know so that we can see how to make sure that imeingia. But if you understand, some of you are understanding, they just want to speak. Some of you are not understanding. So if you're not understanding, do more reading, ask more questions. You can ask me directly if you want. That is fine. You can ask in the group. You can ask me. You can ask your friends. Ask. Are we together? And then we will keep revising them so that you get familiarized on how they're setting the question. But please, 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 read, and read. And don't fear leases. Leases are very short. In fact, there are more things to discuss in transfers than in leases. Leases are very short. Kidogo tu sana. Okay? So that is it, guys. Don't worry. We shall look at more questions, more and more and more as we go, so that everything else become easy. That is it for me from now. Unless you guys authorize me to launch another question, we can do that. But I want to end it there so that you guys can rest. But before we go, again, I'm opening the floor for questions, as many as you want, so that everything can be clear. Questions, questions, questions. All right, there's really no question from you guys. Nobody's having their hand up at all. So I will let you guys go. I will stop the recording and I will share. Ask for the recording now, please. Now.